The real property question from February of 1980 is just about the oldest question we're using in this edition of the Master Essay Method. This is a question that undoubtedly is older than many of my students. So why do I use it? Answer: because it contains some testable issues that are presented in a very useful way. And again, we are going to see plenty of commonality of language between this essay problem and multi-state questions that you've seen before. There's one important respect in which this fact pattern probably can be considered obsolete, and I'll show it to you up front. Take a look at the call of the question. How would you advise client regarding the extent, if any, to which each of the matters referred to in the title insurance exceptions may affect his rights in or to Sandy Acres if he purchases that property? Discuss. Well, you're not going to see any other fact pattern in this course that asks you to advise a client. This fact pattern came out a couple of years before California introduced the performance examination. And so what that means is we are being asked to advise a client, and that's something that really now we do on the performance exam. Still, the issues presented, although they arise in this somewhat different context than many of our questions, we will find interesting and useful issues. Have a look at the top of the question. Oscar is the owner of Sandy Acres, a seafront property which lies between a highway and a public beach. In 1950, 30 years before the date of this fact pattern, he sold Allen an option to purchase the southeast quarter of Sandy Acres for $2,500. The option agreement provides that the option will be exercised, quote, by Allen or his widow at any time while either should be alive. Allen promptly recorded the agreement. Allen and his wife are alive. Well, this is a classic example of a proposition that violates the rule against perpetuities. This is a textbook example of the so-called unborn widow exception. Personally, I much more favor the fertile octogenarian, but we'll put that to the side. Have a look at paragraph 2. In 1955, Oscar constructed a tunnel through a sand dune on Sandy Acres to provide convenient access to the beach. He also conveyed to neighbor, an adjoining owner, a right-of-way easement across Sandy Acres and through the tunnel to the beach for the use of neighbor and guests of neighbor's motel. This deed of conveyance was acknowledged before a notary public whose commission had expired. Okay, let's have a quick pause. The mere fact that a notary's commission has expired does not invalidate the deed of conveyance. Neighbor promptly recorded the deed. In 1979, the tunnel collapsed and it hasn't been reconstructed. That's another difference that occurs to me between this fact pattern and the others that we're going to look at in real property. Here, everybody who gets a deed actually records it. In paragraph 3, we learn about the events of 1962. Oscar grants Sandy Acres for value to Edward in fee simple so long as he never marries. Another condition that you are likely to see on the multi-state, but which doesn't show up on the essays terribly often. Edward, who had no actual knowledge of Oscar's transactions with Allen and neighbor, promptly recorded his deed. Edward is alive and unmarried. Client is now negotiating to buy Sandy Acres from Edward. Client plans to build a resort hotel, a portion of which will be situated directly above the collapsed tunnel. A title insurance company has agreed to insure client's title to Sandy Acres, subject to exceptions as to any limitation on its use or any claim of interest therein which might arise out of each of the following matters: the option agreement, the conveyance to neighbor, the conveyance to Edward. And then we get the call of the question again. How would you advise client regarding the extent, if any, to which of these matters may affect his rights in and to Sandy Acres if he buys? Okay, fair enough. Please take a look at the outline of issues that I present. Here, I follow the call of the question very simply. First, I focus on the option agreement, then on the conveyance to neighbor, and then on the conveyance to Edward. And now, all of the issues that we are looking at are very conventional and readily all of them could appear on a modern incarnation of the California bar exam. So let's have a careful look at how I have fleshed it out. First, we focus on the option agreement, and up front, I acknowledge that probably it's a valid option. It doesn't look as if there are any defenses to the formation of the option contract, but the option itself, on its face, violates the rule against perpetuities. But modern courts probably would define the rule narrowly and not allow it to destroy this option at this time. Next, we focus on the conveyance to neighbor. Here, again, I think that there's been a valid interest conveyed, an easement in this case. I have a separate heading and a separate section for a discussion of the notary. Then we focus on the validity of the easement, abandonment, and then we reach a conclusion. As we look at this analysis a little bit more carefully, we're going to see that it's actually a little bit more complicated than this superficial outline might make it appear. Then, finally, with regard to the conveyance to Edward, here we focus on future interests. The interest conveyed to Edward was a fee simple determinable, but public policy may get rid of the limitation and award him a fee simple absolute. So the actual black letter law being tested here isn't that complicated, and there isn't that much of it. Also, we've got another comparatively short fact pattern. So once again, we've got to be meticulous and comprehensive with regard to our analysis of the facts. So let's take a look at my example answer, and you'll see right up front I lead with the facts in just a couple of short sentences to set up the analysis that follows. We focus on the option agreement, and again I lead with the facts. With regard to Oscar, he sells the option to purchase the southeast portion for $2,500. Alan recorded the agreement. The option contract thus is properly formed. But the problem with the option agreement is that it violates the rule against perpetuities. And notice, I spent 3 paragraphs, 2 of which are reasonably substantial, analyzing the facts. Up front, I define the rule against perpetuities. And here, although I don't go into boilerplate detail, I do get the essence of the rule down up front. Then I indicate that we have the so-called unborn widow example at hand, and still, it is, in my judgment, unlikely that a court will strip this completely and destroy the option agreement. So I say client does face potential complications based on the option agreement. And that's the analysis that I present under Part 1C with regard to the courts in modern times waiving the strict application of the rule. That would mean that this option would remain a cloud on title. And I do think that's the correct answer. Next, we turn to the conveyance to neighbor. And here again, I think a valid interest has been conveyed. I focus on the notary's acknowledgement in the context of the overall facts of the conveyance. The deficiency is a merely technical one. The deed properly is recorded, and it does serve to put other parties on notice. So I reach the conclusion that this easement is valid and that abandonment of the easement doesn't terminate it. And if we look very closely at the language, I think we could make a very reasoned and reasonable argument that the conveyance actually is of 2 easements. One across Sandy Acres and another through the tunnel. So the mere fact that the tunnel has collapsed doesn't mean that this easement has been terminated. I think there is a valid easement across Sandy Acres, and even if the tunnel has been destroyed, I think the easement is still valid. I think the client is subject to this easement that Oscar conveyed to neighbor, even though the tunnel has collapsed. Next, we turn to the conveyance to Edward. Here we have to classify that interest. It is a fee simple determinable because the fee simple interest can terminate in the event of an occurrence. Here, the marriage of Edward. The problem here is that conveyances that restrict the fundamental right to marry may be deemed void as to public policy. Not the entire conveyance, just the term that violates public policy. So probably this conveyance to Edward is going to be valid. and it also will serve to present a problem to the client. So the bottom line here is the client is facing three possible clouds on the title, and the title insurance company is acting well within their rights and, in fact, acting wisely to refuse to insure against them.